All right, so we'll go ahead and get started. My name is Ron Rather. I'm a partner at Troutman Pepper. I've had the privilege and honor of attending RSA and speaking for a number of years. Started out working on the Choice Point and Reed Elsevier breach in 2005 and have been having fun with everybody in the room since then. So one of the things that I was thinking about coming in this morning is how many people were out late last night. I think everyone who planned to attend today stayed out till like 5 a.m. You are the ones that were so dedicated to wanting to hear about this topic that you guys all came in early last night, got a good night of sleep. And it kind of came up to me in the sense of thinking about Monday morning quarterbacking. So for those of you that aren't from the States, that's when you wake up on Monday and you criticize the coach and the team of how they played the day before. And so I'm not criticizing anyone here today about what you did last night. But if somebody, there is a mic, if somebody wants to come up and start off with a confession this morning so we can judge you, that's how you'll feel on Monday, right after the incident. So I will say that there's been a topic of interest for me for a number of years because my specific role as it's evolved is to handle litigation and regulatory investigations. So I kind of come at this from a different perspective in some respects. I'm really looking at the Monday morning quarterbacking, the way that plaintiffs' attorneys and regulators are criticizing the CISO and the organization after they've been through the fire, after they've put the fire out and the house is no longer smoking, sort of the criticisms of what the company did either before the incident or during the incident. In 2016, I did a presentation on how do we better prepare for litigation? What is it that we ought to be doing to making sure that we're ready for that Monday morning quarterbacking? And since nobody listened to me in 2016, I brought a panel of experts along. And maybe people will start listening to them. So I've had the fortune of being able to use each of the individuals on this stage in litigation. They provided their expertise. And if you haven't been involved in litigation and you don't know exactly how it works, we have to tell a story. Right? We got to take a complex set of facts and distill them and then communicate them to a judge. And when I first started doing this, I was in front of judges that would print out their emails, dictate their response to the email, and then their assistant would type the response to the email. Sometimes that's the audience that we're dealing with and trying to explain these complex issues. And what I'd like to do is have each of the panelists now introduce themselves and talk a little bit about what they've done in terms of expert testimony in this space without divulging any confidential information about any of our mutual clients. You can talk about other clients all you want. So go ahead, Linda.
Sure, I can start. My name is Linda Shao. I'm a managing director at Ankara. I have a background in econ, accounting, finance, and computer science. For the past, I think it's almost close to 25 years now, my work has been focused on assisting companies and counsel on litigation matters, particularly class action lawsuits, some of which stem from data breaches. My specialty is in data analytics, complex data analytics, and that involves kind of the design, the development, and the analysis of data-intensive models. And a lot of times, at least for class actions, I'm involved during the class certification phase, analyzing class ascertainability, issues related to commonality, and also issues related to damages.
My name is Matteo Tomasini. I'm a managing director and head of the cyber practice of Prescient, which is a consulting company, and also founder and CTO of District 4 Labs, which is a dark web data company. And my focus primarily in terms of the breach litigation space has been on serving as an expert in the kind of deep and dark web aspects of an investigation. So looking to see, when I'm acting as an expert for the defendants, looking to see whether the data that was exfiltrated or in question is available on the deep and dark web, ascertaining, to what extent the plaintiffs may have been damaged by the release of this information, whether that data is actually there, what other data might have been associated with them, and then also rebutting experts who are making similar claims, but as we'll kind of discuss in this process, kind of fall for some, have some issues, I guess. I'll leave it there.
Hi, Keith Wojcicki. I'm the Managing Director with Kroll. I run a global head for cyber threat intel for Kroll. I've been testifying for about over 20 years. Started my career with the U.S. Secret Service, where I did forensic investigations and expert in forensic analysis. Then I got into intelligence and ran the intelligence section for the Secret Service, and then testified attribution, primarily with Eastern European Bloc. I was an expert in the Eastern European Bloc, Moldova, Russia, Ukraine. Then was lucky enough and fortunate enough to work with Kroll, where I've been deposed several times on attribution with class action, looking at deep and dark web, forensic investigations, kind of all of the above. But like the two of them said, we do all kinds of different work, but the main goal is, how Ron said, is just tell the story, but tell it with scientific evidence and facts and our experience. So it's a fun game to play, and throughout our careers, I'm sure we have a bunch of stories that we can tell you that you would be surprised on either side and what we can and can't do. I think this presentation really kind of goes through that. So thank you very much.
I appreciate everyone being here and participating on this panel. Now I'll say, don't attribute anything we say to any of our companies that we work for, and that's the disclaimer. Anybody here want to take time to read it, like the privacy policies or the terms of use? All right, so what I want to start off with is really thinking about why we're here and what we're talking about and putting some things into context. And by that I mean, we're going to look at a lot of different aspects of an incident and responding to an incident. And what I want to do is now think of it in a different way. So rather than talking about the technical aspects of having an incident response plan or a tabletop, instead I want to focus on sort of how that work and that effort gets filtered through the lens of an expert. So it starts to educate you on not just going through the technical requirements of an incident and how to respond to it, but thinking about how this is going to appear when it shows up on a screen like this in a court, or when it shows up on the desk of somebody at the FTC or somebody at OCR, how they're going to react to the documents, the information, your efforts that you're going through in the midst of putting out that fire. But I think one of the things in having done this for a long time, and I think it's more of note now than ever, because more companies are providing notice. They're not just glossing over whether they have to provide notice or not, right? We're now getting a large amount of lift from agencies and trying to pursue companies that should provide notice under the law, but they don't. We're kind of moving past that era of incident response. But the consequence is there are thousands of incidents now, thousands of breaches that require notice. How do you know that this is the one that's actually going to get the attention of a regulator or a plaintiff's attorney? And Keith, do you want to speak?
Yeah.
Were you ready for that?
No, but I'll talk
Okay.
anyway. I'm always open for it. I think there's multi factors on how people approach it. One is it in the media? That's one thing. Like, if is it a famous ransomware group or attack, or does the client or the defense have a big hand in many organizations that may cause harm, reputation harm, financial harm, stock prices drop rapidly. That's I think kind of the classification they're looking for regulators, and why kind of be prepared that this may be a litigation. But again, you never know, and so as we go through this, there are certain aspects that people need to keep in mind on day one that are going to be very, very relevant on day 1001. And so, and to forecast that is very difficult unless you treat every case like it's going to be in litigation.
And I kind of back up for a moment and look at the SEC and what the SEC has done in terms of reporting and talking about materiality. So if I break down materiality into three simple core components, what's the information that's been compromised? Is it trademark? Is it trade secret? Is it PHI? Is it PII? How sensitive is that information? That starts to get to materiality. The second thing is business interruption. And so what's kind of interesting to me with business interruption is I look the trends over the last 20 years, or however many years that would be, almost 20 years since 2005. And what you see is that question of business interruption and materiality changing somewhat. And I think today what we're looking at is the events that are getting the most attention are what? SolarWinds, MOVEit, maybe Blackbaud. And what am I seeing with respect to those three companies and why they're getting so much attention is the effect that they're having on the overall market. They're vendors that are providing software solutions that are affecting a large number of customers across multiple verticals. The last thing would be, as Keith mentioned, finances. Will the incident have an effect on the financial reporting, the financial performance of that company? And those factors, I think, are going to start to educate us on what's material, but also, is this going to get attention? But going back to the theme of this, last year we talked about the GC and the CISO coming together, right, to try to deviate this blame game that happens, this Monday morning quarterbacking. So that's where we get the title of, are you going to be a hero or are you going to wear orange? We could talk about SolarWinds, right, and being a whistleblower, right? We could talk about Uber and what happened with the Uber CISO, and more interestingly now is we could talk about the SolarWinds CISO and the claim that the SEC is bringing against him individually. But I will also tell you that I took this slide, and I took this slide from the presentation I did in 2016 because I'm still bitter that nobody's doing what I asked them to do. And what I'm asking people to do is make my job easier, right? Mm-hmm. So one of the points I made in 2016 is, why are our cases settling? Why aren't we getting through discovery and into class certification and going to the court and saying this claim is BS? And the reason is because we have documents, right? We have evidence. We have statements of individuals that frankly are not very flattering. They're not based on facts, they're based on opinion. And as a consequence, companies were settling. We are starting to litigate, actually getting into class certification motions. We argued on March 3rd the class certification motion in the Blackbaud matter. So I was hoping we'd have an opinion before today so I could get up and wave our good result. I don't know if we're going to get a good result, but we should get a result any day now in the Blackbaud matter. So we are starting to litigate these issues, and experts are becoming more and more important along the way. So we're going to talk about some of, generally some issues like incident containment and remediation, sorry about the typo, remediation efforts. But we're not going to talk about how to really contain an incident or how to engage in remediation efforts. That's going to be a context for our discussion, but really what I want to hear from our panel is, what's the Monday morning quarterbacking that's happening? What are we seeing in the litigation? What are we hearing from plaintiffs' experts? What are we hearing from the government? And Matteo's going to start us off, because I think in each of these sections what I was hoping to start off with is sort of low-hanging fruit. Like, what are the things that we're seeing companies doing that experts are seeing that, man, I wish they had done it a little bit differently? And so Matteo's going to kick us off with incident containment and remediation efforts.
Sure, thanks, Ron. So just to take a quick step back. So obviously what one does post-incident, how you remediate the incident, is going to be viewed critically by opposing counsel, by opposing experts, et cetera. But so too is kind of what you did to prepare for an incident, the proactive measures that you took to try to avoid an incident. Again, we're not going to prescribe what you should do, but basic things like enabling monitoring, logging, patching software systems, training your employees, not to click on phishing emails or to report incidents, et cetera. And just showing that you're being proactive is going to go a long way. That's something that I'm often asked to kind of weigh in on is, all right, what should the company have done or what should they not have done to avoid this incident? And that burden might be higher depending on what your regulatory agencies govern you. And we're seeing that as more and more breaches occur, that guidance is shifting and changing. Government, regulatory bodies are being more explicit in their assertions and what constitutes bad security practices. And you want to be on the right side of that. But then kind of coming back to the kind of post-incident piece, one of the things that I found to be kind of critical is that you, when responding to an incident, you document as much as possible. And that not just helps with internal, external investigations, but also can give you a leg up should it come to litigation. But one caveat there is be careful about what you document, right? And I've seen people maybe in the heat of the moment might send an email with information that they wouldn't want to be brought up in litigation later. And one of the other kind of trends that I've noticed is that opposing counsel are asking for early memos, early emails, it's going further and further back. So just be mindful of that, and just kind of.
I've been a victim of that.
Yeah.
I may have sent an email or two that was brought up in my testimony a couple times. I've learned my lesson.
Yeah.
Well, then you don't meet Einstein's definition of insanity then. So, at least we know Keith is not insane.
No, not yet.
So.
Not yet, at least. The talk isn't over.
The talk isn't over yet, that's right. And it's kind of an interesting point, and I want to focus maybe a little bit more on the recover, evaluate, and the post-incident analysis as well in this context. Because, anybody else read the Phoenix Game? I always like to bring up that book. I don't know if anybody's read it. The Phoenix Project, I mean. So it's written by an ops guy, and he's talking about how he takes a brick and mortar company, and they're developing this mobile app, and he saves the company. But what I like about the book is how it references the CISO. There's like 6 references in that book to the CISO, and this will have relevance, I swear. And it's not very flattering of the CISO. It's kind of like the CISO is the one that shows up to the meeting with the binders and says no. And why am I going through this? Because I think there's a natural human instinct to when the incident happens for people in the CISO's organization to say, I told them about that 3 years ago, why don't they ever listen to me? Right. I can't tell you how many cases I've had where there's been something like that or something similar that's been messaged within the company. Maybe true, maybe not true. It's not a good document for us to have to deal with in the litigation. And so, when we get to recovery and evaluate, and we talk about post-incident, what we advise and what I've said in 2016, and I'll continue to say it, is state the facts. Don't state opinion, right? So if the fact is that there was a proposed change that was made in 2016, state that you made a proposed change in 2016. Don't say that they don't listen to you, because as we know, a risk-based approach to cybersecurity is much more complex than taking one element of an overall system or structure that we're putting in place and saying, oh, that's what, if only that had been fixed, this criminal wouldn't have been able to exploit us. But I can tell you, when you're in front of the court, the document that the plaintiff's attorney is showing to the court is that one message from that person that said, I told them 3 years ago and they don't listen to me. So in that context, Keith, tell us about the recover, evaluation, and the post-incident analysis, and what you've seen, what you would recommend to the audience in terms of how to address that going forward.
It's tough, right? So there's a lot of complex items that can happen along the way, especially when, coming from, we'll talk about government for a minute. So every case in government has the potential to go to litigation because you're arresting an individual, you're trying to put him in jail. Typically, though, in the federal government, it's usually foolproof that AUSA is going to take it just because they know you're going to win, right? There's rarely a time when you don't. I've been on both sides, but regardless, there's things that can affect that, like emails, like you said, or some kind of statements. But also, it's documentation. It's like Mateo said, documentation is huge. With the Secret Service, people would rotate through. Like, the core mission of the Secret Service is to protect the president. But you're doing investigations throughout the way. So there may be another agent that's going to pick up that case. And that could happen anywhere in any private industry as well. And if you're not documenting what happened, what went on, what went forward appropriately, and it's all, if it is opinion based, that's going to really be biased towards the relevant facts of the matter. So documenting factual scientific evidence of what you said, what you did, moving forward is vital to a successful, litigation. Addition to that, another factor that can determine some type of question is the software itself. If I do a cell phone, like an iPhone 8, back in 2008 or whatever, whenever they came out, and then the litigation's 3 years later. Now we're on iPhone 13, 12, whatever, and the software itself upgraded and is taking more data. And we need to know this stuff. We can redo the examination because the investigator left. That's not the best thing to do, and it probably won't be able to do it because it's a completely different perspective. Your intelligence on different types of collection have increased. I guess even the learned knowledge of that type of information, it has been improved. So you have to go back to the day the event happened and pretend you're going back to the future and understanding specifically what was going on. And so these are some of the struggles that you face without proper documentation and forensic analysis that's done in a way that can be testified accurately in court by anybody, any expert that knows how to do those potential forensic investigations.
So we do acknowledge that you're in the middle of a fire, right? And I've been doing technology a long time, and even people that write code document really well, right? Exactly. So my point being is that we're giving you advice, right? You're going through the fire. We all know that muscle memory it becomes a critical factor when you're in the midst of a crisis, right? So, and Plaintiffs' Counsel always make fun of me, like how soon will Ron talk about the fact that he teaches scuba diving? Well, I waited almost 22 minutes before I mentioned scuba diving, right? It's like scuba diving. You start to get muscle memory, and when that crisis happens at 100 feet, right? You're not panicking trying to figure out how to do. So my point being is we got to start practicing good documentation. So when we're going through tabletops and we're talking about the technical aspects of it, or we're having a board level tabletop exercise, why aren't we talking about documentation? Why aren't we talking about things like, what if Ron leaves in the middle of the litigation of the regulatory investigation? Ron's no longer available to explain what he did. How are we going to deal with that?
Yeah.
I was just going to one kind of quick point, and I think segues into kind of the next couple of slides, is the importance of setting up privilege properly at that stage as well. That's the last point I wanted to make on that.
Yeah, I was just going to add about the importance of documentation is also there's an element of time. Litigation usually happens many, many years after the fact. Memories degrade. Coming back, 5, 6 years, trying to discern what somebody wrote and what they could have meant by a particular phrase is difficult. And oftentimes, if you're opposing counsel, if you're a plaintiff's bar, things can be taken out of context, and it becomes very, very difficult, particularly, as Ron mentioned, if that person is no longer there to kind of answer for that, or if they no longer remember. Then what in those instances, then what's on paper, that becomes fact. And that can be a hurdle depending on kind of what's written.
So let's dive a little bit deeper into the forensic investigation itself. And Linda, some thoughts on specific to artifacts and logging and that process that a company goes through during the incident that then you have to analyze later on in the litigation.
Yeah, so in the work that I do, a lot of what my team is doing is kind of determining who are the class members, what are data elements associated with that class members, issues related to notice, how big is the class. And in my experience, oftentimes companies will do initial assessments. There's usually quite a lot of pressure to kind of get some numbers on the table. How many people are we talking about? What's the time frame? What type of data is associated with this breach? And kind of in those initial analyses, a lot of times there's assumptions built into those. And I think it's important, going back to kind of the documentation part, in terms of being very clear on like, what do you know are facts? For example, are you analyzing the entire data set that could be breached, or are you sampling? And if you are taking a sample, what type of sampling are you doing? Is it something that's representative, or is it something that you can easily get your hands on? And really being able to like document kind of what are your assumptions, so that later on, when folks like me or others are going back and doing a deep dive in the data, if there are differences in numbers, in, for example, social security numbers, are they encrypted or not, and what is the quantum of that, we can help explain why there may be differences between what the initial assessments were and what we're seeing 5 years later, having the ability and the time to really dive into the analysis.
If I could kind of follow on that. I think one of the also critical things is, definitely documenting, but having a process that's defensible, that's repeatable, that can kind of stand up to scrutiny, and to be hyper aware of how the process works exactly, right? You can't just, should it come to litigation, say like, oh yeah, we used AI to figure out how many people were in the class and what was affected, et cetera. You need to be able to say, all right, this is how we identified social security numbers. We use this regulation. This is how we identified credit card numbers. And it makes it, much easier for experts, depending on what side you're on, to just see that process has been clearly thought out. And if it's something that you've done in the past, if it's at the end of the day, as long as it's repeatable, defensible, it's going to be hard to fault you on the process.
I think in every case, almost every case I've testified in, there are dozens of them, and everyone was about process. Okay, you did this one. Have you done this before? Where is it written down somewhere? Have you trained on it? Is there a process approved widely throughout this group or this industry? Every single time, it's really strictly about process. And if it's repeatable, you have it written down, fantastic. If you don't have it written down, that's okay too. But it's a continuum of every case that you're doing. There's nothing different. I think that's actually extremely vital to success as well.
Well, I think, and not having it written down makes it easier for me as an attorney attacking you to impeach you, right? Because everyone's memory is faulty. That's why we need AI. So all I got to do now is get container in this presentation. Then I think I've hit all the marketing. Oh, I got to say XDR. Then I've hit all the marketing, right? Terms if I do that. But I do want to make a quick point because the committee asked me to talk about privilege real quickly. So when I was a young attorney, what my mentor told me was, everything that you write, assume that it's going to get blown up and shown in front of a judge. So that's my advice to you, right? Be careful, think about what you're going to do before you write. What I will tell you is, I've been talking about being careful, but I want you to be candid with me, right? Which is why you want to bring the attorney in. So I will tell you in 2006, when I was giving these speeches, I would tell you, hire an attorney right away. There was no self-interest at all in that statement, right? Today, what I'm telling you is still hire your attorney. But when you want to be candid and you're talking about opinion, not just facts, because I can't change the facts, but when you're talking about opinion, you want to share something, share it with the attorney in the room, because I can claim privilege over that. I can't claim privilege over facts, and I can't claim privilege over efforts that you're taking that result in a business change, right? So business advice, that's the line where privilege ends, and it's cloudy. That's why lawyers exist, right? We deal in the gray and the ambiguous. But let's talk about, it's just some of the pitfalls that we've seen in forensic investigations. I don't know. We don't need to necessarily go through all these in the slides, but do Linda or anybody on the panel, do you want to talk about reliance on file tree provided by the threat actor? And the reason why I put that up there is, ransomware creates a kind of interesting set of circumstances for us, especially when we're talking about multi-extortion ransomware, right? Where they're now exfiltrating information. They're saying, I'm going to post it, embarrass you. It's going to create goodwill issues. And then you say, I'm still not paying. And then they put it up on the dark web, Mateo. And now, what does that mean for the company? What are the differences that the company now needs to do in its forensic investigation? And then more critically, how does the threat actor posting this data on the dark web, attributing it to my client, how does that affect my litigation posture? You can answer the first question. You can answer the second one too.
Sure. So I mean, it's never a great scenario when you're learning what data was exfiltrated, after seeing it on a ransomware shame site, and kind of like to the first point, that is something that will get you noticed. So beyond being a vendor, beyond affecting so many different organizations, having your data published there, and a lot of times what we'll have to do is because the company didn't have great logging, or because it's complicated to collect all the data that might have been involved, we might have to rely on what a threat actor posted to the dark web. So oftentimes we'll take that data, analyze it, and again, have a process for identifying what data is there, how many people were affected, and potentially using it to attribute the incident as well. But it becomes tricky, but to kind of keep on the point earlier, it is just about having that process in place, showing that you've done this before, that you know what you're doing, that you're familiar with the tools that you're using, and can speak. I mean, a lot of times people will post data that isn't associated with an organization and claim it is that organization. I've seen that recently with some healthcare organizations. So being mindful that threat actors aren't always super honest. So you need to evaluate things and again have and document that process. I mean, very, very clear in why you're stating your opinion, how you reach those conclusions.
Yeah, and one other thing that we've seen in litigation is where the threat actor has promised to remove the information from the dark web, making sure that you take the steps to forensically confirm that the threat actor followed through with their promise, which becomes inherently complex when you start talking about how threat actors behave on the dark web in terms of compiling information from numerous events and posting it and making it available in those compilations. So how do I know it's my data versus Mateo's data versus Linda's data that's actually posted out there on the dark web? Some interesting issues. But fundamentally, and Linda, I'm going to get to you. I'm going to ask you a question here, so I know I ramble a little bit. You have to forgive me. I am an attorney. But so we're going through that crisis, and we're trying to put that list together of consumers that we need to provide notice to. And oftentimes, you're probably getting the advice to over-notify. Oftentimes, you're probably getting the advice of, don't worry if we know whether 100 of them had SSNs or whether 1 million of them had SSNs, because in our notice, we're just going to combine it all together. Or we may say that the lift that's required to analyze a terabyte of data, it's just too much, so we're going to notify everyone. Or the other thing we've seen is in an unstructured data, so a text file, how do you know a 9-digit number is actually an SSN? Do you spend the time and the effort to actually do that analysis? And then do you go further and see, is that 9-digit number a valid SSN that I can correlate to a name that's also in that data? I mean, maybe it's an SQL structured database, which takes me out of my unstructured hypothetical, right? I mean, it gets complex, right? I get that. But Linda, when we get into litigation, now we're talking about, can I figure out who's in the class? That's a big issue, right? And we're going to talk about that here. One of the things that we litigate is, can I figure out who's in the class or not? Which is a very different solution. It's a very different goal, right? Very different endpoint than what I may be looking at when I'm approaching an incident. So, Linda, do you want to talk about your experience?
Yeah, I think with certainly in the class certification phase, ascertainability has become kind of a big issue, particularly with data breaches. And I think the main question here is, to Ron's point of how do you know that the data that was breached is connected to the people that that theoretically are the class members? And I think the controversy kind of comes down to the accuracy and the veracity of connecting data to individuals. And let me just give you an example. Our data is collected by a whole host of companies these days, and oftentimes it's anonymized. Sometimes it's only tied to an email address. Well, I have, at this point in my life, probably 15 different email addresses Some are for me, some are for my family. Like if it's, for my family, is the information that's connected to it for me, or is it for my parents or, my partner, or whatever the case may be? And so there's questions, there's certainly gray areas. The issue with kind of accuracy also depends on, the type of data that was breached. For example, if it's employment data, that tends to be a little bit easier to connect, right? Like my company has a single database with my name, my social security number, that's generally connected. But what if it's like sales and marketing data? That gets more difficult to deal with because it may be, my name, an email address, a phone number, but maybe it's no longer my actual phone number. Maybe it's my business phone number. Now, what's the issue? What are the issues behind that? And then also there's issues related to third-party data. Like who's collecting it? How are they collecting it? Or is it self-reported data? I think that self-reported data is always kind of an interesting question because it kind of really goes back on the person. So I was having dinner with a good friend of mine as an example, and we were talking about self-reporting data, and she shared that since leaving college, every single time she's asked or had to fill out on a form what is her income, she always puts $10,000. So for the last 25 years, no matter what it's for, it's $10,000. And so going back to kind of accuracy and veracity, right? Like you need a way, like where is this data coming from? How is it being collected? How is it being used? And that will define like how do you connect that information with the person that may be part of your class.
And there's really some fundamental data hygiene issues embedded in that as well, right? So if we assume that a structured database, that the individuals using that are actually putting the appropriate data in the right fields, or is that assumption wrong? And I think it also begins to blend over to these damage theories that we're seeing, and in particular causation. So now we go back to that scenario of where something's posted or may not be posted on the dark web, and we're now trying to correlate what's on the dark web to what might be forensically within our client's data, and trying to connect the two and say, is what's on the dark web really originating from my client? Are there elements of what's in the dark web data that's attributed to my client that I can call BS on, because there's no way that could have ever come from my client? And Matteo, do you want to talk a little bit about that comparison, that effort?
Sure. Yeah, so kind of on the plaintiff side, kind of what an expert's trying to establish is, as Ron mentioned, that data that they find on the dark web is attributable to this data breach. And some of the kind of common pitfalls that I've found when I'm asked to kind of rebut these experts is that, well, there's quite a few, but just to start off with like two or three.
We won't mention names,
yeah,
of who their expert is.
Right. Is a lack of familiarity with the tools that they themselves are using. And that's something that's kind of taken me for surprise a few times. But, for example, maybe they're used to using, platforms where, by default, it's a or Boolean query. But in this platform, it's by default an and query. So they'll kind of blindly put in these, search terms, get these results, and then report on it. So instead of searching for, let's say, John Smith, and then plus their email address as an and, they're searching as an or. So they're getting results that have just the word John in it, and they're putting that in the reports. And I'm as surprised as you are, and saying that this is from the breach. And kind of the follow-on thing is seeing a lot of experts not validate the results that they're getting back. They're just kind of over-relying on these tools. So like, okay, these are tools that people in the industry use, and they do. But so everything that it returns is going to be reliable, accurate, etc. And I can defend it because it's a tool that everybody uses. And that's fine, but well, it's not fine, right? Because it's not just that you're using the tool. You have to know how to use the tool properly. And so what we see is, maybe someone will, in that example, search for their email address. Like, let's say johnsmith@aol.com, return a result, put it in the report, and then we kind of go back and, I look and say, well, actually, that email address wasn't part of the breach at all. So we're seeing a lot of experts just kind of take these, plaintiff fact sheets, take these lists of plaintiff names, start doing their searches in the dark web, and they see maybe 15 or 20 of them are in the same breach. And they're like, okay, that's going to be associated with this, the plaintiff's breach, without understanding, number one, that maybe that data wasn't in the initial breach. So they're not starting their search right. They need to figure out, all right, what was affected? Let's do the search there. And then, there's been thousands of breaches that have involved hundreds of millions of people. So the likelihood that 20, 30, especially if they're from the same region or from the same city even, are going to be in a particular breach, it's not impossible, right? Like, it could be part of the LinkedIn breach, the MySpace breach, and it might be labeled as such, but might be presented as that. So it's, again, being very familiar with the tools that you're using, having a thought-out process that is defensible, and outlining that process in your expert report. I've seen, again, many instances where people will just come to fantastical conclusions, and there's no way for me to figure out how they came to that conclusion. So then it becomes a question of, but as the attorney would argue, that process isn't repeatable because we don't know what that process is. All we're seeing is you did searches and you have these results, but there's nothing in the middle. There's no fiber connecting the two. So it becomes very difficult to, and we try to figure out, all right, how do they do this? And then you start to see, oh, they completely messed up. They didn't realize maybe there was a bug in the program. Again, like that's another case that I did where someone used a tool, but they weren't super familiar with it, so they weren't able to recognize that there was a fundamental flaw in how their queries were being interpreted by the system. And I saw the results that we're getting. I'm like, that doesn't make sense unless there was a bug. And sure enough, it ended up being a bug, and the whole thing got out of hand.
So I had to get a Cypress Hill quote in here. I don't know why we had to put Cypress Hill, because everybody would have recognized this right away, right? But what we're really talking here is lots of people say they are experts and want to be experts, right? And present themselves as experts. And as Matteo was saying, it's not necessarily always that clear. So I'm sure you guys all drive 5 cars, right? They are superstars, even if not Cypress Hill superstar. But you were talking about some of this, Matteo, and I don't know, Keith and Linda, why don't you add a little bit your perspective on what it means to be an expert, what it takes to be an expert, because it's not really just as simple. It's not simply being somebody that understands forensics, right? Because the judge is going to determine whether your testimony can be considered or not, right? They're looking at a standard in the law to see, are you qualified? Are you using a methodology that's generally accepted within your area of expertise? Are you speculating too much? Are your assumptions wrong? Those sorts of factors start to play into it. So isn't it easy being an expert? I mean, you guys, what is it that you guys really do? I mean, what am I paying you guys for?
It's really easy, actually. You just kind of show up and talk about things. No, but it's difficult, right? So in the federal government, in criminal court, you have to actually be certified an expert. There's a process for that, and you have to almost apply for it in front of the judge. So I'm a certified expert in 2 different areas, but that bleeds over to what we're talking about today, and Matteo just hit it perfectly. So it's not only the tools to be familiar, but you need to understand the concept behind the tools, how they work, why they work, and if the tools weren't there, what would you do? And that's exactly what I do in every case I work and testify. I use the tool as an aid, right? Because it's fast, it's helpful, but then you have to recreate it from the tool too. You have to understand it's collecting information. What information is it collecting? Where did it get it from? Do those places even exist anymore? If we're talking dark web, are they taken down? Why are they taken down? Who were the bad guys? So it's not just, okay, a search result comes up, John Smith, and you have 100 emails. Oh, look, they've been breached. No, okay, it's John Smith. Okay, I understand that, at gmail.com. Okay, that's great. He was part of X amount of breaches. Okay, maybe. And then it was posted by, say, Conti or something, some crazy group like that. Okay, let's talk about Conti now. Now, Conti is a group, right? They may have taken information from multiple different places. But looking at the email and seeing it's been part of many breaches, Well, you know, during that time frame, there really wasn't a breach for that email. But I'll tell you what, like 6 years ago, that email got breached on a compromised account, and then there was another breach right after that. Was it associated with that? So you have to actually do digging. It's 6 layers below. It's not just, here's the evidence, go get it. It's always asking the questions, okay, what if? Okay, where, how, why? If you're not asking those questions, I mean, that's what a true expert does. They're always inquisitive. Even during the testimony, like they're always thinking, you're always wondering, what if? And I think that's what really makes the best experts.
Linda?
Yeah, I think one important element of expert work is kind of understanding, you know, what are the legal standards of being an expert. There are quite a number of precedent that guides, you know, how one can get certified as an expert, and like what are the expectations that experts provide. So for example, in the work that we do, oftentimes either we're rebuttal experts or we're affirmative experts, and there are others that are rebutting us. So the work that we're doing, the opinions, the assumptions, our analyses are being scrutinized by others with our credentials, similar backgrounds, expertise. And so being able to kind of document the work so that it's repeatable by others is critically important in our work, but also being able to make sure that you provide substantial basis for your assumptions. You know, why are you taking, in instances where maybe a tool is not available or it doesn't work in this particular instance, and you're you know, going a different path, you know, underscoring your reasons, your premise, you know, the basis for doing that, tying it back to, I think, the factual record, I think is important as well. I think that's how you get over the hurdles of, you know, getting certified as an expert.
And if you're going to use a referential index, make sure it works.
Yeah. And one more thing, you have to have thick skin. I'll tell you, you have to have thick skin.
You do.
Thick skin.
Any questions? I know we have about 4 minutes. I don't want to cut off questions. You want to go to the mic, or I can repeat what you said? Only because they're recording this. For all the people that slept in.
Good morning, Tracy Lyons. What are some, in your experience, of the best repeatable protocols that you've seen companies do as they, you know, mature in their standard operating procedures with the challenging environment that we currently have? What have been some of the best processes, if you can speak to that?
You guys want to go? Go ahead, Keith.
Sure. I mean, honestly, and this is kind of going to sound a little negative, but it's when an event happens, that's one of the best processes. That's one of the best things, because then they understand what the next steps are. Being proactive. Training is so understated. Yeah, you could do patching, you could do that, which is part of the process. But understanding how the attack happened and to train your personnel, to keep logs, to understand what is vital and how you separate. But honestly, I think almost an incident causes that process to be flourished.
I think if I can add on to that too, I think data hygiene, having a good process of data hygiene is important. For example, you know, a lot of companies keep backup files, right? Like, how long should you be keeping that? If you're storing or collecting sensitive data such as credit card information, you know, should you be cleaning that up, you know, as things are expired and removing that sensitive information? That certainly will reduce kind of your risk.
So we kind of list some of these here, right? Because I would say create muscle memory, right? Do tabletop exercises. Start to create good habits, even before you have that first incident. Make sure that you create visibility, right? Conduct employee training, and in that training, not just talk about the technical things, but start to think about how we're documenting, how we're communicating with each other as a team.
Globally, we're starting to see a divide in opinion on that first call. In fact, there's a session here that says, you know, let's end the debate over what the first call is after an incident. And I know that in the US, we really go lawyer first, breach coach first for the privilege reason. But, you know, in the UK and Canada, Daniel Woods has an article that says how privilege undermines cybersecurity. So how do you balance the efficiency with responding and mitigating with that bring a lawyer in, because the cynical comment on the other side is, well, they're using privilege as a business development tool, trying to get on every case, where some can be resolved on a technical containment perspective.
Oh, I think that's an awesome question. I really do. I think it's phenomenal. And the best answer to that is be prepared, right? Get those people in the room before the incident happens. That's how you correct the balance. Because once you have that group together and preparing for that incident, right, you have paperwork already done, the MSA, the privileges, stuff's already set. So being prepared for that and understanding that it's going to happen. It could be just an email phish. I mean, it could be a ransomware, but understanding that that's going to happen, you get people together initially.
Or what is the trigger point where you decide when you want to be preparing for litigation and bring in the counsel? Because I agree, bring everyone
I see what
in
you're
to
saying, like
decide.
after.
Or like, is it something where it's case by case by case, and are we as the U.S. being too rapid to jump into bringing counsel in, even if something looks like it's not going to go anywhere for litigation? Or do we just assume everything's going to burn?
I think what's hard about trying to make that decision at that first point in time is you don't know where it's going to go. You know, some cases start really small, and then for whatever reason, you know, it gets into the media and it blows up, and you just don't know from a company's perspective. I don't think you really know where you sit in that spectrum. So I think that makes it challenging.
Yeah, and I apologize, we're out of time. I appreciate this panel in educating us from an expert's perspective on some of the things that we do in our day-to-day work. So thanks everyone for attending this morning as well.
Thank you.
Thank you.